Hi, my name is Robert Leming. I'm the director of the We the People programs at the Center for Civic Education, and welcome to today's discussion on government and privacy. Privacy, as you might think, is one of the most important concepts when we deal with constitutional issues. And I'd like to talk to you today about a number of issues, but let's get to the discussion of government in a second. But we're going to be looking at a number of primary documents that are going to help us understand this concept of privacy. The first one is Federalist 51. We'll be dealing with that in just a moment. But we're also going to look at Judge Hand's speech that he gave in 1941, and also Dr. King's quote that came out of the Birmingham marches, and the writs of assistance case in 1761, leading on to the Fourth Amendment, which is obviously most important for today's discussion, the Olmstead case in 1928, California versus Greenwood in 1988, and finally the United States versus Jones in 2012. These are a few of the important cases in American history that deal with the issue of privacy. They're not the only ones, but there are some that we can deal with today, I think, in the amount of time we have. So let's get right to it. But first, before we get into that idea of privacy, we've got to deal with the problem of government. James Madison liked to talk about the problem of government because he believed there was no such thing as a utopian form of government. That if you're going to make a government, you have to deal with the idea of who we are as a human being in that sense. So it was more of the problem of government. And what the founders were looking for in after the American Revolution and the developing of the Constitution was what they called the least imperfect government. They knew there was no such thing as a utopian form of government, but if you're going to make one, let's make one that's least imperfect. And so we can argue about whether or not that has come to pass or not in another discussion. But for today's discussion, let's look at where Madison got his ideas about government. All right, Federalist 51. You have all of these handouts in front of you, and if you can't find them, they'll be located on the website listed below. Now, Federalist 51. The first line of Federalist 51 is this: "But what is government itself but the greatest of all reflections on human nature?" It's clear to me that James Madison understood that human nature is an important idea here to consider when one forms a government. Who are we as a people? Who are we as individuals? Are we good? Are we bad? Well, how did Madison tackle this issue? Well, he looked at authors like John Locke and Thomas Hobbes, who talked about human nature in ways that help us understand who we are as a people. We're not perfect beings, as understood. We make mistakes. Individuals are good, but sometimes people are not, which generates another problem that we'll discuss later on. So, who are we as a people? That's a good question to ask ourselves. Are we good? Or are we not so good? And remember, Thomas Hobbes talked about the status of people in Western Europe, especially in England during the 1700s, as solitary, poor, brutish, and short. Life for most people was not good. And where was government there to help that out? His answer was a Leviathan, a sort of benevolent king, because that was the best form of government he could think of. But John Locke and others, and certainly the founders, got into the idea that if we're going to form a government, we need to understand human nature. And then, in the next line in Federalist 51, Madison says this: "If men were angels, no government would be necessary. Neither external nor internal controls on government would be necessary." So what does Madison mean by this? He's acknowledging that if we were angels in our human nature, we wouldn't even need government. There would be no discussion here, because angels are sort of perfect beings. They know how to do the right thing. They do the good. They operate well. They treat others nicely, and so forth. So if men were angels, we'd be all set. No form of government. But guess what? We're not angels. So here may be the most important sentence ever written, in my opinion, about government. "In framing a government which is to be administered by men over men, the great difficulty lies in this: you must first enable the government to control the government, and in the second place, in the next place, oblige it to control itself. What is he saying here? He's saying you've got to empower government. We can't, if the government's weak, it's a problem. If it's too strong, it's a problem. But you've got to give it some amount of power. How much power? That's up for our discussion. All right? But at the same point, you've got to oblige it to control itself. And what does he mean by this? He gets into the concept of civic virtue. Goodness inside of people who are operating government. You have to give them power, but at the same time you've got to hope that they have some amount of civic virtue and when they're making their decisions. And that's sometimes difficult. We have good people ruling over us and sometimes we don't. But that is the difficulty here. Empowering government, at the same time oblige it to control itself. Now, Madison goes on to say this: a dependence on the people is no doubt the primary control of government. What is Madison talking about here? He is suggesting that people, because they give up their power to government, are the primary control over government through elections, through referendums, through writing letters to members of Congress or to their officials and so forth. Us being the watchdogs of government. All right? Because why? Because they're not angels. We put people into power who we know are not angels, who are imperfect beings, and have them rule over us. Well, that's a scary proposition in one sense. So we have to be the control of government by exerting our powers back over it. You see, we give up our power to have other people rule over us. Well, we don't give it all up. And that power that we do possess is supposed to be acted on as a watchdog over government. But Madison goes on and says this: but experience has taught mankind the necessity of auxiliary precautions. Yes, people have power. Yes, people need to exercise that as a watchdog over government, but that's not enough. Mankind has taught us the necessity of auxiliary precautions. Now, what are these auxiliary precautions? Well, Madison goes into Federalist 51 later on. We won't be discussing it today. But he starts off with the problem of government and then goes into the answer later on in Federalist 51. And one of those answers is auxiliary precautions, which are separation of powers into three branches: the executive, the legislative branch, and the judicial branch. The dispersion of power within those branches. We have a Congress that's made up of two bodies. We can't even trust one body. We have to break that up as well into a Senate and a House, all right? Because power in one individual is too much for us to handle. We experienced that underneath the king prior to the American Revolution, and we want now to disperse that power out by having separation of powers, and also other auxiliary precautions like checks and balances. One branch can check another. If the legislative branch makes a law that's unconstitutional, the Supreme Court can come in and declare that act unconstitutional. Here is where Madison also acknowledged another problem. Excuse me, it's the problem of government by itself, but when you talk about tyranny, prior to the American Revolution and prior to the Constitution, if kings rule over you, the tyranny comes from the king. The king might be nice and might not be so nice, but our threat to liberty is from the king, all right, or for one individual or his buddies, if you will. Madison acknowledged a new threat to liberty, and that is the majority, all right? If we're going to give all of us power and a majority rule, then all of a sudden now you have a new threat to liberty, because people, good-willing people, think they're doing the right thing, might create laws through their legislature or through a referendum process that are unconstitutional. And what I mean by that is deny others liberty because of this particular law. Madison understood this and was in favor of a very energetic court that would check the majority of the people. Okay? Now, let's go on to Learned Hand. Judge Hand, probably one of the most famous judges in the United States history who wasn't a United States Supreme Court judge. He gave a speech in 1941 to new immigrants coming to the United States in a celebration in New York City. And he said this: "I often wonder whether we do not rest our hopes too much upon constitutions, upon laws, and upon courts. These are false hopes, believe me, these are false hopes." Now, what is Hand getting at here? He's saying that yes, you can have this perfect or this least imperfect design of a government that Madison lays out and others, and that created the Constitution and so forth. You can have all of this on paper and it sounds great, but that's not enough. We can't rely just on laws and on courts and on constitutions. He says, liberty lies in the hearts of men and women. And when it dies, there's no constitution, no law, no court can even do much to help it. While it lies there, it needs no constitution, no law, no court to save it. What is Hand getting at here? It's not enough to have a great document. It's not enough to have amendments. It's not enough to have these checks and balances. It's not enough to have separation of powers and so forth. It has to be in our hearts and our minds. The people who are being governed have to, in a sense, buy into the system by embracing the ideas of the Constitution, embracing rule of law, embracing the idea of privacy. If they do that, a Constitution is almost not necessary because it's in our hearts and our minds. So we have two things here that are into play. One, Madison's ideas about how to form a government, again, the least imperfect kind of government, and then Judge Hand coming along and saying, that's not enough. We have to have it in our hearts and our minds. We have to embrace this as a way of thinking. Okay. Then, what happens if government breaks down, or is the problem? Because you remember, Madison talked about government as a problem, and how do we solve this problem, all right? Empowering it at the same time obliging it to control itself. There have been times in American history when government is the problem, and people have to take it to the streets, if you will. People have to embrace these ideas and make government understand. Well, in the United States, we have a glorious time of the 1950s and 60s when Dr. King and others pursued liberty for those who were disenfranchised, African Americans, who were living all over the United States, but were not getting the same rights that others had in the United States. And so in Birmingham in 1963, Dr. King said this: "There are those who write history. There are those who make history. There are those who experience history. I don't know how many historians we have in Birmingham tonight. I don't know how many of you would be even able to write a history book, but you are certainly making history, and you are experiencing history, and you will make it possible for future historians to write and capture a marvelous chapter. Never in the history of this nation have so many people been arrested for the cause of freedom and human dignity." Now, King is talking about the thousands of children who participated in the children's marches in May of 1963 in Birmingham. Young people using nonviolent tactics and understanding that under the Constitution had a right to do this, broke laws in Birmingham that were made by the state legislature and by city councils and so forth that were disenfranchising them in terms of their liberty, and took it to the streets and took it to the world, if you will, because the world saw this on TV, these young people expressing their rights and their right to be included in the bargain. If all men are created equal, as it said in the Declaration of Independence, those famous words by Thomas Jefferson, then why aren't we included in that? These children went to jail for it. When all of this was resolved, the dam of segregation in the United States, the apartheid system we had in the South especially, started to break. And young people are responsible for that, led by African American pastors and men of religion to create that. So the point being here is that at one level you can have a system of government that's in theory the least imperfect we can get, laid out by Madison and others. And then, as Learned Hand so interestingly says, now we also have to embrace it in our hearts and our minds. But ultimately, if we have to get it ourselves through the rights that are guaranteed in the Constitution of assembly and speech and so forth, by taking it to the streets and showing that government is wrong and that needs to be changed. And that happened in American history in the 1950s and 1960s. Okay, what does this all have to do with privacy? As I said, privacy is one of the rights that Americans embrace. Now, interestingly enough, you will not find the word privacy in the American Constitution. But you will not find the word federalism or the word judicial review, and those are certainly important concepts that we embrace in the United States. So where has this idea of privacy come from, and how did our founders think about it, and how has it transformed over time within the United States? And that's what we're going to look at here in a moment. But I want to get to a chart that Madison talked about, because on here you're going to see something in terms of rights. First of all, when we speak of rights in general, none of them are absolute. Even though it says Congress shall make no law in our Bill of Rights, no rights are absolute. The only one that I can think of that might be considered absolute is our right to conscience, our right to think what we want without anybody having, or any government being able to change that. Now, the problem is, obviously, in a country where they might use torture, governments might be able to even limit that, your right to conscience, by finding out what you know. And obviously, remember, we were warned in George Orwell's book, 1984, that could government become so powerful that not only could it find out what's in your head, but then change you so that you're no longer a threat to society. That is true power in a government's hand. Let's talk about privacy. It doesn't exist in the Constitution by the word, but it's certainly implied in some places, all right? And I think the easiest one that we can point out, obviously, is the Fourth Amendment to the Constitution. That's where you find privacy. Let me read it to you. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, prior to the Fourth Amendment, and what were the reasons why we have a Fourth Amendment in the United States Bill of Rights, are interesting to me. And there was a case in 1761, and it's called now the Writs of Assistance case. And what writs of assistance were general warrants issued by the king that allowed the federal government, or the government of England, to intrude on the privacy of individuals into their homes by flashing this piece of paper. Now, it was a general warrant, meaning it wasn't specific to any one person or one thing. It just allowed the government officials to come into homes. Now, to be honest, there's a lot of smuggling going on right now, avoiding taxes and so forth from England, and therefore the English leaders just thought they needed some kind of writs of assistance in order to counteract that. So in one sense, the British are thinking this, and the colonists are thinking this is an invasion of our privacy. It comes to head in 1761. At that time, James Otis was the Advocate General in Massachusetts, all right? And he is asked to defend the writs of assistance because he's a government official. he resigns his position because he's so distraught about this practice. So what happens? The Boston merchants hire him to defend themselves against the writs of assistance in court, Superior Court of Massachusetts. And in fact, Otis does this for free. He says, I don't even need a salary for this. I'm so passionate about these ideas. And in a 5-hour speech, he sets up the idea that this law is unconstitutional and is barbarous. And obviously what came out of that was the Fourth Amendment of the Constitution, of the Bill of Rights. Now, what's interesting as well is that in that courtroom is a young John Adams. I believe he was around 25 years old. He sees this case and he leaves the courtroom and he says, then and there were the seeds of the American Revolution. One could make a case that the American Revolution, which probably had many causes to it, but certainly a big one, was the idea of privacy, and reflected in the ideas of the policy of the writs of assistance. And so Otis loses this case, but what's gained out of it is the impetus to the American Revolution, which comes years later. He says, it appears to me the worst instrument of arbitrary power, the most destructive of English liberty and the fundamental principles of law that ever was found in an English law book. That's his criticism of the writs of assistance. Now, one of the most essential branches of English liberty is the freedom of one's house. A man's house is his castle, and whilst he is quiet, he is as well guarded as a prince in his castle. This writ, if it should be declared legal, would totally annihilate this privilege. Now, again, he loses the case, but some would argue that right here, the seeds of the American Revolution are apparent because of privacy. All right. Now, remember, the founders' concept of privacy was more in the line of private property. The idea of violating your own private property in your home. And you can see that reflected in the words of the Fourth Amendment, that it's talking about giving the government power to trespass on your property. All right. Now, specifically because of the Otis case, it now has to be with a search warrant, and it has to be very specific, and it has to have a third party, a judge, verify the search warrant. A police officer can't just write it him or herself and then go into a house. All right. Now, as I said earlier, no right is absolute, except maybe the right to conscience. And so even the Fourth Amendment, over time, has been limited, advanced, changes, and so forth. This is the bigger idea here. You know, issues of constitutional law are for the generations that live. Even Thomas Jefferson said that, you know, when the founders are all gone, the next generations have to interpret the Constitution themselves. It's for the living. You should not be sort of tied to something that was original from the founder's idea. Although it's certainly important to consider what the original founders believed about certain ideas of constitutionalism, and especially when it comes to privacy and the ideas that protects us from. Now, the amendment is very specific about homes, but we're going to see with a few cases how this has changed over time. Because one of the interesting aspects of privacy is technology. What was the technology like in 1798? What was the technology like in 1920s? What was it like in the 1980s? And what is it like today? And how does that impact our lives in terms of privacy? And any democratic republic needs to consider that. If privacy is going to be an important right that's protected by government, remember, because we institute governments to protect our liberty, they also have the power to intrude on our liberty. And how can they do that in terms of privacy? Well, This comes to play in a big way in 1928. You have a gentleman by the name of Roy Olmstead living in Seattle, Washington. He's a police officer. Well, at the time, he's not making a lot of money, so he decides that he's going to, as a part-time job, start bootlegging. Now remember, an amendment had been passed that outlawed liquor in the United States. So they changed the Constitution. Liquor was legal, now it's illegal. All right, so, but many people didn't like this law or thought the law itself was unconstitutional. Roy Olmstead was one of those. Well, he goes into business for himself. After he's found out as a police officer, he's fired, but he becomes a full-time bootlegger. And in his heyday, made almost $2 million a year on bootlegging in the 1920s. All right. Now, the interesting fact is, the people who worked for him did not use guns. They paid off public officials, they paid off other policemen, they paid off folks to leave them alone because they believed that they were acting against this amendment that they believed was unconstitutional. And that they had really a higher calling, and that was to deliver alcohol to the northwest of the United States. Well, what did the police do? The police decide that they're going to wiretap Ralph Olmstead's phone, all right? They do it without a search warrant. And they listen to Roy Olmstead's phone conversations for 6 months. They don't record it, but they listen and write it all down. And he has conversations with his girlfriend, he has conversations about bootlegging, all kinds of private conversations are recorded. Then they arrest Ralph Olmstead on the charge of selling alcohol in violation of federal law. Okay? He claims that his right to privacy has been violated, that his Fourth Amendment right to be protected against unreasonable searches and seizures has been violated because the police did not have a search warrant when they entered his home. Well, the court, in its wisdom at that time, and here's what they had to discuss. Did the use of evidence disclosed in wiretapped private telephone conversations violate the recorded parties' Fourth and Fifth Amendments? The court says no. And the reasoning they use is that, well, the police did not trespass onto Roy Olmstead's home. They listened to wires outside the house. They were connected up to wires outside the house. The Fourth Amendment says entering somebody's home and securing papers and effects. They didn't do that. And they declare him guilty that this was not a search protected by the Constitution. This was not a search protected by the Constitution. Therefore, the evidence gathered was used and he was found guilty. Now, out of that came probably the most important dissent in American history. There's others, but this certainly is up there. And that is by Justice Louis Brandeis, who I'll paraphrase, thought about what kind of technological devices are coming down the pike in history, in the future, if you will. In 1928, the discussion was about wiretapping, which didn't exist during the founding period of the United States, but did exist in the 1920s. But what's coming up that we can't even contemplate yet, that certainly Madison couldn't contemplate, but even the people who lived in 1928 couldn't contemplate in terms of, will these technologies allow privacy to be violated beyond the Fourth Amendment of just going into somebody's house? And so he writes this important dissent that in 1967, in the Katz case, K-A-T-Z, Katz, in the Katz case, the court says, look, the Fourth Amendment is about people, not particularly places, homes, or whatever, but myself. So wherever I'm at, I'm protected against unreasonable searches and seizures from the police. And that means they need to have a search warrant and so forth. Now, obviously, there are exceptions to search warrants. And in 1914, and then again in 1961, the court it created, if you will, it's not in the Constitution, the exclusionary rule, and applied it at the federal level in 1914, and then later in 1961 in the case of Mapp versus Ohio. But the point here is this, that if evidence is gathered in an illegal fashion, meaning no search warrant, then the court can throw it out, even if somebody is really guilty because of that. The police can't use unconstitutional means to gather evidence. It puts a burden on the police to follow the Constitution. Well, what happens then is that people are somewhat upset in 1961 because now the courts applied this at the state level, and all of a sudden you have, quote, guilty people getting off on technicalities because the search warrant was written wrong or was the wrong house and so forth like that. And, quote, guilty people are going free. Well, what does the court do? It starts to carve out exceptions to when you need search warrants. The Fourth Amendment exists, but there are times when you don't need a search warrant. For example, if the police are in hot pursuit of somebody they suspect of being a criminal, they don't need to go and get a search warrant. If they see something going on right in front of them that's illegal, they don't need to get a search warrant. It's in plain view. It just makes sense, and that you would give them an exception to that. But how far do you go with these exceptions? Okay? In 1988, an interesting case came up called California versus Greenwood. Billy Greenwood was a suspected drug dealer, and why I say suspected, because the police suspected him because the neighbors complained that Billy had a lot of car traffic coming to his house at all times of the day, all right, and at night. They had an informant, a known felon, who said Billy Greenwood was a drug trafficker. Well, the police decided they needed more evidence in order to get a search warrant. That wasn't enough, so they didn't go to a judge. They decided to be clever, and they asked the trash collector of Billy Greenwood Street to pick up Billy Greenwood's trash and separate it into the trash truck for them to look at later on. Well, when the police did look at it later on, they found evidence of narcotics use. Boom, they get a search warrant and they go in and they bust Billy Greenwood for possession of drugs and so forth. Now, he claims this is a violation of his Fourth Amendment rights. The police didn't have a search warrant to do this. They just did this on their own. They should have gotten a search warrant to go through my trash. Isn't my trash mine? Don't I have a privacy right to my own trash? Well, the question comes up. Did the warrantless search and seizure of Greenwoods Garbage violate Fourth Amendment search and seizure guarantee by the Fourth Amendment? All right, well, did it or did it not? Well, let's think about that for a second. When I'm in my house and I have trash and I throw it underneath my sink where I keep my garbage can, is it mine? Do I have a right to privacy? You'd probably say yes. Well, now that can is full, so I take it and I put it in the garbage can in my garage. Well, is it mine? Do I have a right to privacy? Probably yes, because it's on my property and so forth. Now it's Thursday night and I got to take that garbage out. So I pick up the garbage can and I'm walking out. I'm in my driveway. Is that mine? Most people would say yes. All right, now I'm at the end of the driveway and I set that garbage can down. Is that garbage mine? Do I have a right to privacy to it? I leave. Now, what happens? Do the police need a search warrant to go into my garbage that's set on the curb? Well, the answer to that came in 1988 when the court voted 6-2 and held that the garbage placed at the curbside is unprotected by the Fourth Amendment. The court argued that there was no reasonable expectation of privacy for trash on public streets that is readily accessible to animals, children, scavengers, snoops, and other members of the public. The court also noted that the police cannot be expected to ignore criminal activity that can be observed by any member of the public. So the point being is that by a 6-2 vote, the court said, you put trash out, you no longer have an expectation of privacy there. all right? So our court is limiting our privacy expectations, if in fact we believed we had privacy in terms of trash. And here comes an important point here. It's up to us as citizens in a democratic republic to decide what we want private and what we don't, and what we give up or not. You know, at some point there's going to be discussions about internet privacy and so forth and how. And so far we don't have any privacy there. The court's going to have to catch up on those areas, all right? But a case came out in 2012, which I find very interesting. This one was decided just recently. When the police decided to take a GPS system and put it on a car of a suspected drug dealer without a search warrant and follow him around to find out where he's going. Well, that seems pretty clever. Take this GPS system, put it on the truck without the knowledge of the person there, and we'll just follow him around. After all, we think he's a drug dealer. Can't we do that? Well, it goes to court. And Jones is arrested because the GPS, they find him guilty. Well, it goes to court, and and here the constitutional question is this: did the warrantless use of a tracking device on Jones's vehicle to monitor its movements on public streets violate Jones' Fourth Amendment rights? Interesting question. The court, in a 9-0 decision in 2012, said yes, it violated his privacy rights. Justice Scalia delivered the opinion of the court. The court affirmed the judgment of the lower court and held that the installation of GPS tracking device on Jones' vehicle without a warrant constituted an unlawful search. The court rejected the government's argument that there is no reasonable expectation of privacy in a person's movement on public thoroughfares, and emphasized that the Fourth Amendment provided some protection for trespass onto personal property. So you've got two sides here. One arguing if you're in public, you don't have privacy rights, and Jones and his advocates obviously said, yes, we do. You can't just monitor my goings about by putting a GPS system on my car without a search warrant. And that's what Justice Scalia said. Look, if you want to monitor this guy, get a warrant and put. It's not the problem of the GPS. There's a thing called the Fourth Amendment, and you better follow that. And that means get a warrant if you're going to search this guy, because his privacy matters. And we believe that, I think, in democratic republics. Okay. Obviously, in terms of privacy, there are other issues that need to be dealt with, but not at today's discussion. There are certain cases of Roe v. Wade and the Griswold case in terms of birth control. Those are other issues of privacy that I think one ought to explore. But for today's purposes, the idea that technology is creeping in and creeps along in terms of history is one I think we need to contemplate. Where are we going with this? Will there be anything that's private in the future? Because of the government's ability through technology to invade our privacy. And remember what Madison said in Fellows 51. We are the watchdogs of our government. It's up to us to decide how private or not private we want our society to be. And we use the court to help us decide where we're going with that. And notice that over time, different peoples think different ways about privacy. Today, it's up to us to decide how private or not private we want to live. In the future, it will be up to others who might embrace privacy or say, you know what, that's a foolish idea. We don't really need any privacy because it's not good for the country. Well, I think that what we want to contemplate here today is how do we want to live? And remembering that all rights are not absolute. There are limits on our privacy, but the question is, what are they? Are they reasonable or are they not? And remember this too, just because a court, the United States Supreme Court or other courts say that this is the way it is, it doesn't necessarily mean that it's correct. it's the law of the land today, but sometimes there's dissents. Like in the case of Olmstead, where Justice Brandeis had the foresight to see that the decision in that 1928 case was wrong, and was vindicated some years later in 1967, that privacy expanded beyond the idea of just being in your homes and your houses. So with that, I'll leave you for today, and hope that you investigate these ideas and come to some conclusions about your own thoughts about where privacy is and how it exists in your mind, and where should and how much of it or not have of it should we have in a democratic republic. Thank you so much for listening, and we'll see you next time.
Keep on rocking in the free world. Keep on rocking in the free world. Keep on rocking in the free world.